conservatorship case. However, you'll see here that there are provisions for pretrial conferences, motions, discovery being the fancy term for the exchange of information between parties as to what they intend to present at a hearing to support their position. There are limits on the amount of discovery that can be done in a guardianship and conservatorship case, but the parties involved also have a duty to confer with one another to try to narrow down the issues for the court's benefit. They have to file a joint report with the court, again, that outlines what they're exactly fighting about. And at the end of the day, there's an evidentiary hearing. This is like a trial. And in guardianship cases, there is a statutory right to have a jury trial, but it has to be requested within the first 30 days of the filing of the case. And if you don't demand your jury trial, you waive it. Something to keep in mind, and I have done this on more than one occasion, is that these cases can be settled. So they can be referred to the court alternative dispute resolution program, and I think every court or every county in the state has an ADR program. And I think the thing that works best in this instance is mediation. So mediation is where a third party neutral is assigned to the case, and they facilitate a discussion among the parties to try to iron out their differences. So sometimes that can be because the incapacitated adult doesn't like the person who's petitioned to become the guardian or conservator, or it could be because two kids are fighting over who should be guardian and conservator for mom. I mean, there's lots of different disputes that arise in these cases. So this is just a way to try to get settled without a full-on evidentiary hearing, which can be complicated and expensive and frankly quite destructive to the family at the end of the day. Once appointment occurs one way or the other, there are continuing responsibilities that the guardian and conservator have to comply with. The first is guardians do have to file 2 reports on an annual basis. The first is an annual report of guardian, which is a report by the guardian about how what we call ward at this point, the incapacitated adult, how that person has been doing over the past year, any significant changes in their well-being or placement, and whether the guardian believes that continued guardianship is necessary. There's also a report filed by the doctor who sees the ward on a regular basis. And again, it's just an update about how they're doing, whether there have been any significant changes in this person's medical or psychiatric condition. As I mentioned earlier, if the guardian does have that inpatient authority to put the person into a psychiatric unit, it has to be renewed every year with a motion that's supported by the report of the doctor, in particular a psychiatrist or psychologist. Now, in Coconino County, these guardian reports are put onto the judge's non-appearance calendar. The probate rules did change again at the beginning of January to say that we no longer have non-appearance calendar or non-appearance hearings, and so I just don't know how that's going to play out. But the bottom line is that the judge doesn't want people to have to come to court if they've already filed the necessary reports. The judge can read them and approve the reports and set the next hearing without having to see anybody. So it's just meant to streamline the process a little bit. And so I think in reality that these hearings will continue to be non-appearance, but we'll see how that goes. Okay, as I mentioned earlier, the conservator has a lot on his or her plate. And there's a tremendous burden, especially for non-professional conservators, to comply with the requirements of statute and the probate rules. So among other things, the conservator within 90 days of appointment has to submit an inventory of assets, a budget, which is, gee, what do we think we're going to have to spend for the incapacitated adult this year, and how much income are we going to receive? A copy of a consumer credit report, and they also have to do something called record the letters of conservator in any county where there's real estate located. So quite a bit on the front end. And then through the course of every year, they're going to be keeping track of literally every penny that comes in the door and goes out the door on behalf of this individual who's incapacitated. And that information is submitted to the court, and we call it an accounting or an account. And it's submitted annually, and it's reviewed by someone called a court accountant. Again, I don't believe that every county has a court accountant, but we certainly do here in Coconino County. So the other thing the conservator is tasked with is a constant evaluation of how sustainable the conservatorship is. Sustainable being the term of art for, do we have enough money? How much